Right, well, it's 12 noon and we have a jam-packed presentation today, so we will get started and I'll continue to let people in as they join. So as I said, welcome everybody. Thank you for joining us today as we focus on domestic violence and our criminal justice response. We are joined today by Allie Friend, who's Deputy Chief of the Criminal Division from Winnebago County State's Attorney's Office, as well as Haley Smith, who you're going to hear all about her position, which is brand new in the last couple of years and something innovative that we've done through our grants here at Winnebago County. I will say before I turn it over, if you have any questions, I'll be monitoring the chat. So feel free to throw those questions in there. I also will put the PowerPoint for today in there as soon as we get going. So without further ado, I'll turn it over to Haley and Allie. Thank you.
Thank you. Thank you everyone for coming today. Hopefully we can get through this in a very fast and efficient way. We kind of have a lot of things that we want to cover. So the first half will kind of be spending how the state's attorney's office as an attorney perspective responds to domestic violence prosecution when we don't have a witness to come in person to testify, meaning the victim. As well as the second half, talking more so in depthly about Haley's position and all the things that she does for our office so we can proceed to prosecution without a victim if that is what our case is looking like. So she'll be able to describe more in depth her role. So I just kind of want to first start off with the scenarios that we're talking about. This is mostly in line with cases where the victim is, quote, not cooperative, and we have been unable to get them to court to testify in the criminal case. So this is not for the scenarios where the victim is cooperative, where we have been able to be successful in having the victim served with the subpoena and him or her coming to the courtroom. This is kind of our response as to how to deal with the scenarios where we are proceeding on evidence-based prosecution without the victim. So I just want to throw that out there. This is also, just so it's clear, there are certain procedural steps that the state has to make in order to proceed to a prosecution without the victim testifying. This does not negate the requirement that we have a duty in order to try to bring the victim to court. So this is kind of our response if the victim's not there. So first and foremost, if this is a case where the victim is not cooperative, we've either not been able to get a hold of them, they've told our office that they're not coming, we've been unable to serve them with their subpoena. This is kind of what the attorney's next steps are doing in the lens that we're working under. So the attorney in our office is going to re-review the files with a different lens. Basically looking through the file to see if there's any other potential witnesses that could come in and testify. That might include obtaining a DCFS indicated packet. When DCFS is called, DCFS is interviewing the victim. They're interviewing the children that were present in the home. They're interviewing sometimes the suspect or the defendant regarding what had occurred. So they could be a potential witness for the prosecution in the trial. We're also going to be re-reviewing the file to see if there's any EMS or fire response that was made on scene, to see if the victim had made any statements to the medical professionals that they came into contact with. So that could be an EMT, that could be if they went to the hospital and were treated by a nurse practitioner or a doctor. Ultimately, as we all know, anytime you go to a medical setting, people are asking you questions about how you became injured, what type of pain you're suffering. So those statements sometimes can be used by the prosecutor as well, and I'll talk a little bit about that later. We also are going to then proceed to reviewing other police reports that involve these same parties. So have police responded to this residence previously and help us be able to have someone testify as to who the defendant is, for example, who the victim is, what their relationship is. Also in those other police reports, we might have other witnesses that might have observed a prior domestic battery, for example, that could come in. The attorney's then going to look through full court, for example, to see if there were any orders of protection that have been filed involving the same parties as well. That could include the same victim. So if the victim in your charge case is no longer cooperating with the prosecution, but she had originally made a sworn statement for an order of protection, that could also be another piece of evidence that the state might be able to use. As well as if there were other individuals who have obtained orders of protection against the same defendant. Sometimes we can file propensity motions, which is basically anytime there's a pattern of abuse involving the same defendant, we can file motions to try to bring in that past pattern of abuse, whether it's the same victim or former paramours or former victims that have been in place. And then the last thing, and that's what Haley will talk about later, that we'll look for is whether or not there were jail calls made to the victim from the defendant, tablet messages, video messages. So when we are re-reviewing our file, as I talked about, looking for other potential witnesses. So that's going to include what statements did the defendant make? Any statements that the defendant has made on scene to police officers or other investigators is admissible at trial. The defendant's statements are always going to come in. So if the defendant's on scene and said, Mary Smith is my girlfriend, that helps us establish an element of the underlying offense as well. We're also going to look for 911 calls and see if it is deemed to be an excited utterance, because we can also file a motion in limine to get in the 911 call itself. That 911 caller could certainly be the victim. It could also be another individual who might be driving by seeing a domestic incident occurring. Sometimes that 911 caller is not interviewed by police officers. It's just noted that someone else called it in. So the attorney's going to have to do a little bit more digging, trying to figure out who that person was, if it's not the victim who called 911, and determine if they actually witnessed a domestic act, and then try to locate them to bring them in. We can also, regarding the 911 calls themselves, there's a way as well that if you can't bring the person who made the call into trial, we can also subpoena the 911 dispatcher if our motion is granted by the court. So as I mentioned before, regarding DCFS investigators, there have been plenty of times where I've had a subpoena DCFS investigator to come in to testify. They can be great witnesses who can clarify who the parties are. So the victim in the case, the defendant in the case, and what their relationship is. So, and as I stated before, looking in our police reports to see who else was present or who else did the victim call to respond to the scene other than the police. So that could be neighbors that might have seen what had occurred, family, friends, children that are present. So in regards to the DCFS investigators, there are certain motions that we have to file in order for them to be able to get in to testify. So, and this kind of relates to all of the witnesses, so I kind of want to package them together. There are a few different types of motions that the state can file. So I'm going to kind of skip ahead on the slide. So this is the statute of unavailability for domestic violence cases specifically. We refer to it as 10.2A motions. that the state is filing. So this is not in the context where it's forfeiture by wrongdoing. It is just before the forfeiture by wrongdoing application that we can use. The 10.2a is basically in a domestic violence case, if the state has made reasonable efforts to obtain their appearance in court, and that person does not avail themselves to the court process, then the state can rule that non-testimonial statements are admissible in trial. So the first prong of the state's analysis, as well as the judge's analysis when determining whether or not to grant these motions, is whether or not the victim is unavailable. So unavailable could be a few things. That could be certainly the obvious, that that person is not there, they're not present in court. It could also include a lack of memory. So if a victim does testify in the trial and states that they don't remember anything, this subsection for the domestic violence prong deems that as another way of that victim being unavailable. So you can use their statements at the trial as well. Same with if the victim gets on the stand and refuses to testify despite a court order ordering them to testify, then that's another way that the court can deem them to be unavailable at trial. So talking about the scenario where someone is unavailable and we've tried service and things like that. So first, the victim is served but fails to appear in court. So we have been successful in getting the victim served with a subpoena to come to court, but they are not following that court order. You can also, I think I lost a slide in here, but I'll talk about the scenario with, I've had this come up before. So a victim was served with their subpoena by an investigator in our office, and that victim ripped up the subpoena in the investigator's presence and said, "I'm not coming to court." So I was able to present that evidence and proffer it to the court that we have made reasonable attempts to have that victim come to the hearing or to the trial. In that scenario, the court did grant that motion stating that the victim was unavailable. We had made every attempt to get them to come. We actually did successfully get them served, and that victim was continuing in refusing to come to the court hearing. We can't physically drag victims, nor would we want to the trial, but that was clearly showing that that victim in the scenario was not available to come. Another example of this is, so we have in our office now an investigator who is dedicated to helping, especially on our felony cases, serving subpoenas to domestic battery victims. So when our investigator gets that list, you know, that he's documenting how many attempts he's made at that residence. If he believes that they've changed their phone number, maybe moved away, he's conducting his own investigation as to any updated information surrounding that victim, such as work, new addresses, other contacts, family members, and trying any reasonable means to locate that person. We've had a scenario where, for example, our investigator has gone out to the known victim's address, has attempted to make service, has made contact with them literally on the phone and saying, "I'm outside your door, can you please answer the door?" And the victim indicating that they're not going to answer the door. The investigator then left their card at the door, returned a few days later, same thing was happening. They were refusing to open the door. So even though technically they weren't served with their subpoena to come to trial, we were able to establish through the investigators' notes and attempts at service that we were being reasonable in our attempts, and we were unsuccessful in having them come. So the next analysis of whether or not the victim is unavailable, the next prong is whether or not those statements that were made are testimonial or non-testimonial. So in the context of non-testimonial, it has to be almost like an excited utterance. So the first statements that are made to police officers, for example, when officers are responding on scene and asking, what is happening, the statements in regards to what is happening could be deemed to be non-testimonial. Some other non-testimonial statements could be, to their mother, to their best friend, to a neighbor about what had just happened, even if it's not to law enforcement, those statements could be deemed to be non-testimonial and to come in at trial. Now, the next prong, and Haley will be able to talk more about this aspect of it for the forfeiture by wrongdoing. But before we get to all that Haley does for her job, I just want to touch base regarding what forfeiture by wrongdoing is. This is basically when not only is the victim unavailable to come to trial, but the defendant themselves has somehow made it so the victim isn't coming to trial, or in the case law, it talks about acquiescing in their unavailability. So this is a scenario that we commonly have when someone is in the jail. It's easier for us to frankly prove in this respect because they're in the jail and all their calls are monitoring. So if someone is not in custody, it makes it a little bit more difficult to prove up forfeiture by wrongdoing because we don't have recorded statements. But in the scenario where someone is in the jail and they're calling the victim and telling them not to come to court, to write an affidavit, to tell the state's attorney's office that you're not cooperating and you're dismissing charges, all of those statements combined can equal a forfeiture by wrongdoing motion. Ultimately, it's up to the court to decide if the defendant's behavior has risen to the level of forfeiture by wrongdoing. There is case law that talks about even just playing on someone's feelings and emotions for that relationship. For example, if I'm the defendant and I'm in jail and the victim is my girlfriend and we also share children in common and I'm the one that's working and I'm the one that's paying all the bills. If I'm making statements to the victim saying, well, now that I'm locked up here, no one's going to be able to help you. Our family can't be together. You're going to have to raise the kids by yourself. Things that are playing on the emotions of that victim and for her future family life and making her feel sad for the defendant, but also feel like she has to make a choice of what she's going to do for her family or to hold him accountable. Things that are considered cajoling of the victim's feelings can also be deemed to be a forfeiture by wrongdoing. So it doesn't have to just include threats of harm, that if you don't do this for me, I'm going to have someone come after you, for example. That is not the requirement for forfeiture by wrongdoing. It is a wide variety of statements that could be made. So when the attorney is looking to see if forfeiture by wrongdoing is in play, we're certainly going to be looking at jail calls, tablet messages, jail letters. For a period of time, I think inmates thought we weren't looking at their letters, just listening to their jail calls. So they were sending out messages through the letters instead. As well as having their friends or family reach out to the victim. And sometimes it's the family members of the victims that are letting us know that this is what's going on behind the scenes. So those are all of our different options that we can look to determine if forfeiture by wrongdoing is occurring. Now, on the legal side of it, why it's kind of easier in a way if it's forfeiture by wrongdoing from a prosecutor standpoint, because all of the statements should be coming in. It's not limited to whether a statement is testimonial or non-testimonial. It's just all the statements are coming in. And I don't want to spend too much time on the legal distinction for that because it really only depends or really only matters for like the lawyers on here about that distinction. But it just, for its most simplistic view of it, forfeiture by wrongdoing is a high threshold to make from a prosecutor's standpoint, like to reach that argument. But then once that motion is granted, it's an easier case, especially with body cam these days, because we're not relying on summaries made by police officers anymore. The body cam is kind of speaking for itself as far as what the victim had said. So I'll turn it over to Haley so she can talk about all the things that she does in her new role and how wonderful it is for us as prosecutors to have her with us. So thank you.
Hi, everyone. My name's Haley Smith. I work for the State's Attorney's Office, and I just wanted to introduce myself because unlike Allie, I'm sure a lot of people don't know, you don't know who I am. I started the State's Attorney's Office in 2020. I was a victim service provider. I was actually in the Domestic Violence Assistance Center, helping file emergency orders of protection for victims of domestic violence. And then from there, I moved up to, I did that as well as the misdemeanor division of domestic violence cases, being a victim service provider. And then I began this job October of 2022. So it's been a little bit over a year that we have created this position, and I have started it and we've tweaked it to what the prosecutors need. This position was also funded by the court's Improving Criminal Justice Response Grant, and it was recently refunded, so I get to keep my job. I'm just going to begin by going over the purpose of my position, which Allie kind of went over. There's an obvious trend, or it's like a myth, but it's not a myth. Cases involving intimate partners, the victim becomes uncooperative with the prosecution of the case, which is no fault of his or hers by saying uncooperative. They just are not willing to participate in the prosecution. There's a million explanations of why this can happen, but we're noticing that whether in custody or out of custody, they are able to get the victim to write an affidavit, call the State's Attorney's Office to drop the charges and not cooperate with us. This obviously can lead to further abuse, and so the cycle kind of starts again. But my job was created to help limit the dismissals and catch the abuse that was happening from inside of the jail, and to help with the forfeiture by wrongdoing motions. Here is an example of what the jail calls look like that I get to see and listen to every day. There are calls from booking, there are calls from the defendant's PIN number, which is the number listed right next to the phone number. They're often not trading pins, but using each other's PIN numbers, either in exchange for commissary or just as a favor, like, hey, can I call my girl on your PIN number? That's another way that we're finding jail calls. And then just calls to either the victim's phone numbers or using code names is another way that I'm able to find them. This is an example of what the tablet messages look like. I don't know if you guys can really see that, but the inmates are given a profile under their PIN number, and then people from the outside of custody create a tablet profile, and they can create whatever name they want under a phone number or an email, and that's how they communicate back and forth. Photos are allowed to be shared to the inmates, but not inmate to outside person or the victim. So often that's how we're able to identify who is talking to the inmate, is just the photos that are shared with them, or even they'll take a picture of the affidavit they wrote and send it to the inmate asking, like, is this okay? Is this what you're wanting? Video visits is another method of identifying victims. They're conducted in lieu of in-person visits. So I think they're getting away because of COVID of in-person visits. So they're doing video visits instead. So if a profile is under the name Jim Bob, for example, which oftentimes they're using nicknames or different names so that it's harder to identify who the person is that they're messaging. The video visits are really helpful in that I can see who the person is under the name Jim Bob, and if I often compare to body camera images or videos, and compare like, okay, that is her that he is talking to. This is an example of what a video visit can look like. This was kind of a funny story. So this is the case against Kevin Lundgren. We got a guilty verdict in a stalking case a few weeks ago. And morning of trial, I happened to come in at 7 a.m. just to glance over his jail call communication because we thought that she was coming to court. But around 4 p.m. the night before trial, they had a video visit, which is what you see. And he had told her, if you don't come to trial tomorrow, there aren't going to be any consequences. You should take the kids to the park. Nothing's going to happen. This is my roller coaster. So panicking, I hurried up and put it on a disc, and we presented it to the judge the morning of the trial that, hey, like he told her she didn't have to come to trial. And Andrew Markham, he's one of the prosecutors in our unit, filed a forfeiture by wrongdoing motion along with the video, and it was granted. So we were able to start the trial and proceed without her coming because we knew she wasn't going to come, thanks to the defendant. But then over a lunch break, I don't know if he called her or the defense attorney called her, but she magically appeared after lunch was over. So that's just an example of how the video visits can be really helpful, or kind of putting into play the forfeiture by wrongdoing motion and how quickly that can happen. I also do the Pretrial Fairness Act. I screen in the morning for calls on domestic cases or sex cases or anything really involving intimate partners. And those calls can be used in our petitions to detain on domestic violence cases. I won't go too much into that because it's complicated, but I screen in the morning for calls like, hey, he attempted to call her 10 times at this phone number. He said that she should write an affidavit, that she should call the state's attorney's office, and I'll give him a heads up that you're probably going to see her in court this afternoon with an affidavit, and most of the time that happens. I've been dribbling into drafting forfeiture by wrongdoing motions and helping the attorneys start that, just because how I figure out the victim is who the tablet profile is can kind of be hard to put into words. So I like to put the puzzle together first for them and then kind of let them take over. I've testified in hearings and in jury trials and bench trials, which is, as you can tell, not enjoyable for me, but I do it. And then I attached this is a motion that I had helped drafted for one of our attorneys. It's a forfeiture by wrongdoing motion. It just goes through the police report, establishing his PIN number, what phone number he called, how we knew it was the victim. And then in the motion we attach the tablet messages that what we believe created the forfeiture by wrongdoing that he committed. Take care of that situation ASAP today. Don't forget to bring and make a copy of the marriage certificate and turn it in with the other paper. And by other paper, he is most likely talking about an affidavit. And then it goes on like, I love you, I don't want nobody but you. Something is telling me you don't feel the same, after she's not responding to those messages. So it's already like a guilt trip happening. Often I see like phrases, no face, no case, stand on business, don't go to court, or they come up with keywords or phrases where those two people know what it means. So I have to try to decipher what they're saying. Like one couple I had, they referred to court as church, And just through context of listening to all their calls, I figured out that church actually meant court or trial. So we also filed that in a forfeiture by wrongdoing motion, which I had to testify about what that meant and how I knew what that meant. I'm just trying to go through all the tablet messages. Do you really love me? If you guys want to just glance over these, I don't know. I think Nikki will be sending this PowerPoint out. It's too much to read, but and then an obvious one was said on the 16th at 16:05. You know, I don't want you to go to court, Toya, which is clear that he doesn't want her to go to court and testify. I also just put little common ones that I see through messages or over the phone. I won't read all of them, but they won't charge you if you don't show for trial, which is a common misconception. We can charge them, but we often don't. Stay out of the way, worry about getting me home. That's what you should worry about. Don't answer the door. No face, no case. You're good. No face, no case. Often with also the forfeiture by wrongdoing phrases like stay out of the way, don't open the door. They are also threatening the victims or just even preying on their sympathy by saying, you know, if I could, you know, if you drop the charges and I can come home, then like I'll marry you or we'll go on vacation. So it comes in a lot of different forms. And then this is a study that I thought really described what I'm hearing every day. It's just a study where they monitored domestic violence jail calls and what that looks like in terms of getting the victim to recant or just the pattern that they saw. I'm not going to read all of it because it's a longer study, but I just thought it would be helpful to share because it describes exactly what I hear every day. And this is kind of the cycle that they went through. It's not linear or sequential where it's like this happens, then this happens. It's just kind of like, I don't know. It just goes through different ways that they're talking. So to begin, the couple discusses the abuse that happened. There's mutual blame and a resistance of each other's accounts, but often they're minimizing what happens, which is the second number you see. The perpetrator minimizes the abuse and blames the victim to lessen the crime severity. So he's kind of preying on her sympathy and minimizing what happened, almost like gaslighting her, or, you know, that didn't really happen, you're remembering it wrong, which is something I hear quite often. Then the couple invokes images of life alone, bonds over love, memories and dreams, or the position they themselves against others who don't understand them. And then it goes to the perpetrator instructs the victim to recant, and she complies. Instructions are reinforced by sympathy appeals and minimization. And then couple constructs the recantation plan by redefining the abuse to protect the perpetrator, blaming the state, and giving each other instructions. So that's just a common cycle of things that I hear, or just the cycle of the recantation process. So this is just a summary of, I guess. So I have worked on about 260 cases. It changes every day. I usually add about 5 to 10 every day. But about 260 cases within the year, and we're seeing really great success with everything. And we're just increasing abuser accountability and decreasing domestic case dismissals is our main goal.
So I just want to chime in real quick and just kind of piggyback off of what Haley talked about. So the reality is that this evidence has always been there. It's just there's not enough hours in the day to be able to pour through jail calls. So thankfully, with the help and funding of Haley's position, it has helped our office, the state's attorneys, from filing the appropriate motions, because otherwise it's almost like you're drowning. You could listen to jail calls for 24 hours a day and you're barely going to even tip the iceberg on one person's case. So for example, I have a case where he was incarcerated for approximately a year. And he called her 6,200 times. Each phone call, and this is my prior jurisdiction that I worked in, was 15 minutes, because there they cut off every phone call at 15 minutes. So that's 6,200 phone calls, 15 minutes apiece. That doesn't include video conferences either. I didn't have time for that. There's no way in the world I could ever listen to that many phone calls. And then here in Winnebago, there is no cutoff time. Apparently everyone can talk for as long as they want. It could be like an hour and a half. We don't have time to be sitting there listening to an hour and a half, and they also know that. So there's strategies behind what Haley does, what attorneys do when they're listening to the jail calls. That article, Meet Me at the Hill, is 100% accurate. I've been doing this for several years, and in all my experience of listening to jail calls, reading messages, usually within the first 24 to 48 hours, that victim has already started the recantation process. And that's because of the constant pressure from the defendant. Also just the feelings of sadness and going through the cycle of violence itself, because now your loved one is in the jail, you're feeling like it's your fault, you want your family back together, all those emotions are playing on you, and now you're just being inundated with so many phone calls. So that is 100% accurate of how that cycle works, and how the prosecution really hinders strongly on these motions that our legislature has allowed us to use. So the forfeiture by wrongdoing is huge. Typically what happens is after the forfeiture by wrongdoing motions get granted, is all of a sudden magically the victim appears in court to testify. And now it's not a scenario where you're going to trial without your victim. It is now you have to impeach your victim with body cam, basically confronting their original statement with their statement that they're using now. You know, from our perspective, it doesn't matter what form they come in. Obviously, we would like to be able to hold the defendants accountable no matter what the trial itself looks like. So we're trying to utilize all of the statutes that are available to us, all of the motions, Haley's position, so that we can still go to trial even without the victim or with the victim in the recanting, because you can still use the jail calls in the trial itself if the victim comes, and because it goes to their bias and their motive to lie on the stand as well. From the Pretrial Fairness Act perspective, Haley's position has also been amazing to help us in initial appearance court, being able to tell the judge, hey, this person was arrested last night and he's already called her 25 times and has already told her to come to court, and oh, she's here with an affidavit. To me, that goes towards this defendant's level of control over that victim, and that the condition of no contact is not going to be something that's going to be abided by if he's already manipulated her and manipulated the judicial process as well. So Haley's position has evolved to include the Pretrial Fairness Act. It's very similar. I mean, it's almost like the jumping off point for the future forfeiture by wrongdoing motions that are going to be filed, but her position has become vital in our office in order for us to proceed to trial. So does anyone have any questions about what Haley does or anything in general?
Allie, I was wondering, as I'm looking for things to come through, if you could talk a little bit more about what impeachment means, because you both kind of referred to that like very quickly and everybody might not know what that means.
Yes, and I apologize. I use a lot of legal jargon because it's just like in my brain. But so impeachment is if someone is on the stand and they're testifying differently than what they had originally made statements in reference to. So in a common domestic violence scenario, victim on scene is telling police officers what happened, right? The police were called to an emergency response. They ask the victim what's going on. She says, Bobby hit me in the face. So let's fast forward to if the victim does come to trial and she recants on the stand, is the term we commonly use. So she's basically making a new statement that is different than the original one. So what we have to do to impeach a witness is we have to ask them what happened. So let's say she says, I was mad, I lied, I was jealous because he was cheating on me or whatever the scenario is. That didn't happen. Okay, well, what do you mean? Like, how did you get injured? Oh, some girl, I got in a bar fight with some girl. I don't know her name. So let's say this is now the new statement. So the impeachment comes from, isn't it true that police officers responded to your house on such and such date and you had a conversation with them about what happened? They can either deny or admit that, police officers responded to the scene. They can then say, then you have to confront them with the statement. Well, isn't it true that on that date you told Officer Jones that Bobby punched you in the face? So you're confronting them with that original statement. And now with body cam, you can confront them with the body cam video footage itself. It's what we call substantive impeachment. So the jury can consider if they believe the original statement that was made on body cam or if they believe the state that's made now when the person's testifying in court. Another analysis, like for the messages and the jail phone calls that Haley finds for us, let's say the person is recanting on the stand, we have to impeach her. We can also introduce those jail calls where they're talking about their testimony, like what she's going to say happened, whatever kind of story they come up with. We can play that in court as well because it's going towards her bias and motive to lie, and it's directly related to her credibility on the stand when she's testifying. And I'm just, every recording says that they're being recorded. The whole prompt of every phone call says that these phone calls are subject to recording and monitoring. No matter what, even with that prompt, they're talking about everything anyways. They're talking about what stories they should come up with. They're literally reading word for word what they wrote in an affidavit, and the defendant is instructing them on what changes to make. So they're being told it's being monitored. They just don't care. And either it's just a matter of they want to still control the situation, or they don't recognize yet that we are investing our time in listening to the jail calls as well. So only time will tell if that changes down the road too. So
I know we have some advocates on the call and other people that do direct service. How do we kind of mitigate that tension of, well, we know why survivors want to recant, or how can we talk with them about, this isn't a punishment to you, right? But how does the state work with that? I hope you know what I'm saying.
You mean as far as like from an advocate perspective to us, like how we can communicate with the victim that, like, I'm sorry, but I'm going to have to impeach you, or what do you mean by that?
I just think if my advocate brain listens to this, it's like, well, I know why they felt like they needed to make a different statement. And then how do I talk with them about, this isn't you being punished, but this is how the system works, right? This is how these cases are prosecuted, I guess is what I was thinking, of honoring that there's a reason why sometimes they may change what they say.
Right. I mean, I kind of want to be careful because I don't want to give like, my main thing when I'm talking to victims and I'm preparing them for trial, they have an urge, it seems like, whenever I first meet with them, to get out, like, I was lying, it didn't happen. It's like, okay, well, I'm going to disclose that because I'm obligated to do that. And that's fine. All I'm asking you to do is to get on the stand and testify to the truth as far as what you remember happening. That's all I can ever ask you to do. So I recognize that you might remember things differently. All I can tell you to do is that you are under oath, and you have to testify truthfully as to what you remember. You know, we have to be careful because obviously we're not going to be preparing statements for the victim to say. It's whatever they testify to is what happens. I think from a prosecutor angle, it is still treating people with respect. I might be cross-examining them in essence because I'm confronting them with earlier statements. I try to be cognizant of my facial expressions, because although it's frustrating on the inside, I understand why they're doing it. It might be a survival mechanism for them, that they feel like they have no other choice but to try to protect their abuser in some way. And I'm sure for a lot of them, that is their thought process. I'm not going to hold it against them, but it's my job to still hold someone accountable. So I just, you know, I don't try to be a bully about it, but just kind of saying, okay, well, on this day you said that, and on this day you're saying this, and then it's ultimately up to the jury to decide. From like an advocate perspective, I think it's just recognizing that, you know, they're gonna have to testify if they're subpoenaed to come. That they just need to tell the truth as far as what's going on. If they have in your own confidential conversation, some other conversation, I mean, that's for the advocate and the victim to talk about. But from the state's attorney perspective, we just have to be very clear as far as our boundaries, because we're not their attorney. It's not subject to confidentiality for us or our victim service providers in our office. So it's just kind of treating people with respect ultimately, no matter what, from the prosecutor standpoint. So
Thank you. I did not mean to ask you tricky questions. Your colleague Alex has his hand raised, so Alex, you can unmute, go ahead.
I was respectfully waiting for that for Allie to finish, but just to add, everything she says correct, and to add on to that in reference to Haley. So there's a reason we all believe in these cases, and we believe victims even when they're telling us that it didn't happen the way they initially said it happened, or that they weren't abused, or whatever excuse they bring the next day or the next week or after they've talked to the defendant from the jail. The reason we believe in the case still is because we have all the information available. We know the pattern, we know the dynamics at play, and it's so clear and obvious to us all, not just the prosecutors, but many of the people on the call, what's really happening. And the difficulty going to court is only when we're constrained to part of the truth, when all we have is the prior statement and the current statement, and not what's happening with the defendant and the victim from the jail. When Haley's involved in shining a light on everything that's going on in the case, then the new statements aren't even bad. I'm going to lower my hand. They're not even bad. They're further evidence of abuse. I think it strengthens the case when we're able to explain, like, look at, he's continuing to abuse her, and you're seeing the fruits of those efforts, even during the pendency leading up to and including the trial. So what Haley's job and everything she so articulately explained that she does is able to bring a jury or a judge to the same position that the prosecutor's in. And it's so obvious, that's what's been so frustrating for us, is because we so clearly know they did it. We so clearly know that they're abusing their victim. And Haley allows us to say that and to bring everybody on the same page and see what we're seeing behind the scenes. That's all I want to say. Sorry.
Thank you.
Thank you. Are there any other questions or comments for our presenters today? So I want to take a second to acknowledge this presentation is timely because you may have seen in the news yesterday or today, the state's attorney has really been acknowledged for their efforts and how they're addressing these cases differently moving forward. And I think that's thanks to many on the call today. I see Alex. I saw Andrew Markham here, if he's still here. They're both from the state's attorney's office DV unit. Taylor Sagona's here as well. She manages the grant that keeps Haley employed, as you lovingly said, Haley. But I think this is just a testament to how many people are involved in these system-wide changes. And so it's really exciting to kind of see things start to come together. Because this is, I think, even I learned so much about what you do today, Haley. I'm like, this is the coolest job ever. So I think we're all thankful for you in the way that you're changing the culture of the system for sure.
Thank you.
Okay, I'm going to then throw the link for the evaluation into the chat as I'm talking here. I'm not doing multitasking well. So please fill out that evaluation. It is helpful to us. I also threw in the PowerPoint as well as the study that Haley referenced, which I encourage you to look at. It's pretty interesting. And so if you have any other questions about resources, please reach out to me and I can connect you with the SAO team. Any final thoughts from you guys?
Nope.
No. Okay.
Just one more thing. No, I'm kidding. I have nothing else.
Okay, thanks, Alex. Next week, we'll conclude our Lunch and Learn series. So on Halloween, we will meet for kind of a community resource roundup. We'll hear from several of our FECC partners about the work that they're doing around domestic violence, and you'll have an opportunity to hear from them and ask any questions. So we hope to see you then. Thanks for your attendance today and enjoy the rest of your afternoon. Good job, Haley.